Hello and welcome to Market Matters, Thompson Hine's podcast series that explores critical legal and regulatory issues affecting the investment management industry. I'm Mike Wible, a partner in the investment management group. I'm welcoming Nathan Holmes back to the podcast. Nathan was my guest back in November of 2019 when we discussed the SEC's proposed amendments to the proxy rules. Well, the SEC adopted those rules on July 22nd, 2020, and we're here to talk about those amendments. The amendments codify the SEC's interpretation that proxy voting advice generally constitutes a solicitation subject to the proxy rules under the Securities Exchange Act. This was expected and is consistent with the proposal. Despite the SEC's broad view of what constitutes a solicitation, the proxy rules exempt certain solicitations and entities from the proxy rules information and filing requirements. Proxy voting advisors, that is, firms that provide advice to their clients on how to vote proxies, currently rely on these exemptions. The advisors and many in the mutual fund industry strongly oppose some of the proposed changes to the conditions that the proxy voting advisors would need to satisfy to rely on the exemptions. Nathan will talk about some of those concerns later in the podcast. But first, let's take a high-level look at the amendments. When the SEC originally proposed the amendments in November of 2019, they said the purpose of the amendments was to allow investors who use proxy voting advice to receive more transparent, accurate, and complete information on which to make their voting decisions. All right, so let's look at some of the changes. First, under the amendments, proxy voting advisors must disclose any material conflicts of interest either in their proxy voting advice or in an electronic medium used to deliver the proxy voting advice. This amendment was adopted substantially as proposed, but it's a little bit more streamlined. Also, unlike the proposal, the final amendments don't specify where the disclosure has to be made or how the disclosure has to be presented. Second, the amendments include examples of when failure to disclose conflicts of interest or other information in proxy voting advice would be considered misleading. So those are the first two items, and they're relatively uncontroversial, and they were adopted as proposed substantially. The big issue was the next one, and that is that proxy voting advisors must adopt and publicly disclose written policies and procedures reasonably designed to ensure that proxy voting advice about an issuer is made available to that issuer at or prior to the time the advice is given to the proxy advisory firm's customers, and the proxy advisory firm's customers have a way by which they can reasonably be expected to become aware of any written statement from an issuer regarding the proxy advisory firm's proxy voting advice in a timely manner before the shareholder meeting. So the Second Amendment is significantly different from the proposal, which would have given issuers the right to review and comment on the proxy voting advisor's draft advice before the proxy voting advisor's clients received it. So Nathan, why was this change made, and what is the significance?
Sure, thanks, Mike. I think that in the final version of the rules that the SEC has adopted, they've taken a more principles-based approach here in recognition of a couple of things. One, understanding how compressed the schedule is for traditional proxy season. Many public companies are going to have their proxy statements issued, calendar year companies, in a pretty short window of time in the spring, and proxy voting advisory firms need to review those proxy statements, develop recommendations for their clients, and get those out to their clients. And adding in the sort of pre-distribution ability for the issuer companies to review and comment on drafts of the proxy voting firm's advice, I think the SEC recognized that might really make the timeline a little too short and compressed in some situations. The other thing is, I think they were reacting to some of the comments that were received from proxy advisory firms, and others. Institutional Shareholder Services, or ISS, in particular, pushed back really hard on this concept of being required, that was in the proposed rules, where they would have been required to give issuer companies the ability to weigh in on a draft of their proposal and include the issuer company's response in their proxy voting advice when it's first delivered to their clients. They made a number of arguments there, including arguments under the First Amendment of the United States Constitution, which I have to say, it was pretty interesting reading. As speaking as an executive compensation lawyer, I don't spend a lot of time thinking about free speech issues and constitutional law considerations. But ISS was making the point that, well, hey, this is the SEC, it's the government telling us that before we can deliver written advice to our clients, we have to go to someone who may disagree with us, give them the ability to review our comments, and then even be required to include issuers' comments in the original version of our advice that we provide to our customers. So I think the SEC, heard that and sort of took a step back here, and they still want to make sure that issuers have a better chance to sort of weigh in on a timely fashion and get their views out there, but they have taken a more, as I say, principles-based approach in terms of allowing the proxy advisory firms to come up with a policy that might work for how they would implement this, and they've also, relaxed the requirements in that there's no longer, under the final version of the rules, there will not be any requirement that proxy advisory firms allow issuers to review a draft before it's submitted. They just have to be made aware of their advice no later than the time that the proxy advisory firms issue their reports to their clients.
So, Nathan, the final rule also requires that the proxy advisory firm notify their customers that there might be additional proxy solicitation materials that were filed by the issuer in response to the advice being given by the proxy advisory firm. Does that seem to satisfy ISS and the other proxy voting advisory firms, or it is, or not?
Well, this is very interesting. This is far from over, I would say, and there's really not a uniform approach here. One of the very interesting things to watch is going to be how these rules, as they go into effect, and we can come back to what the effective dates are on these various provisions in a bit, how they sort of affect the competitive landscape, for example, in the proxy advisory firm business. There aren't that many companies in that business. By far the most influential in the space that I work in executive compensation, is ISS. And ISS, as you may recall, had sued the SEC before the proposed rules came out, based on some guidance that the SEC had published late last summer. The ISS's lawsuit was stayed, put on hold while these proposed rules were pending. And now that the rules have been finalized, ISS has signaled that they're still intending to keep up the fight. They are going to be making a filing here, an amended complaint in their lawsuit against the SEC. I think it's due by mid-September or so in just a couple of weeks here. On the other hand, sort of the next most prominent player in the proxy advisory firm space, Glass Lewis, has taken a very different approach with respect to the kind of notice and comment provision that was in the rules that were originally proposed. And voluntarily, in the 2020 proxy season, Glass Lewis actually moved towards an approach of allowing issuers and any other proponent in a contested transaction or in an M&A transaction. I should say the ISS or the SEC's final rules do not apply. These provisions requiring disclosure about statements that the issuer may make, they don't apply in the context of contested elections or M&A transactions. But ISS, or I'm sorry, not ISS, Glass Lewis has voluntarily adopted a process which they call their report feedback statement.
Hmm.
So under their report feedback statement approach, if you're an issuer or if you have an interest in these a contested issue on the proxy statement, you can request a copy of the report and make your comments and have Glass Lewis distribute those comments to their clients. So, you know, there's some differentiation here in terms of how the players in the proxy advisory firm market are reacting to this, but at least one of them, and the most influential of the proxy advisory firms, has signaled that they intend to keep fighting.
Mm-hmm. And just to sort of clarify something that Nathan mentioned, the original rule as proposed would have required proxy advisory firms to also deliver statements from other stakeholders in the proxy solicitation process, not just the issuer. That proposal was not adopted, and it's just the issuer now, not any other person involved in the solicitation. Nathan, do you think there's any significance in that change?
Not a. I mean, it's interesting. Actually, the proposed rules, could have allowed other parties to weigh in. It wouldn't have applied to shareholder proponents. I think the rule said like any party other than who's involved in a proxy solicitation other than certain exempt solicitations. So solicitations on behalf of a shareholder, the shareholders wouldn't have had an ability to weigh in, but in a contested election, you might have had a shareholder proponent be able to weigh in. Certainly that it's an interesting approach to it, and frankly, that was one of the things that I think ISS is one of the things they're likely to complain about. They're saying, look, you're only allowing the issuer to weigh in, and the issuer is probably unlikely to weigh in unless they disagree with our voting advice. So we'll see how that plays out.
And getting to that piece, I can perfectly understand the logistical considerations and the time and the delay and what that does to the proxy process, both for the issuer as well as the client who needs to make a decision and cast their ballot within a specified period of time. But what is I'm sorry, because Glass Lewis doesn't have this issue, but what's ISS's main beef about allowing the issuer to express their view of the advice?
Their main beef is really the way in which the SEC might have required them to be involved in that process in any way. Of course, issuers could always submit additional proxy materials, file them with the SEC, challenging, the comments that a proxy advisory firm makes. And in fact, I think, earlier in the days of say on pay, again, as an executive compensation lawyer, that's one of the places where I see proxy advisory firms influence being very important. In the early days of say on pay, if a company were to get a negative recommendation from ISS, often the instinct was to file additional proxy materials with the SEC and really come out swinging against any perceived inaccuracies, methodological weaknesses, incorrect points of view that the proxy advisory firm stated. Subsequent to that, I think more recently in situations where you might have a challenge from a proxy advisory firm, companies have really tended to move more in their disclosure towards, one, being proactive and reaching out to their largest institutional investors, really taking a shareholder engagement approach to understand what their investors are interested in on a variety of topics that could include executive compensation. And even when additional proxy materials might be filed in response to or in connection with an election where ISS or Glass Lewis has made a negative vote recommendation, I think more recently the tendency has been, not to mount an attack on ISS or Glass Lewis, right? But really to focus on just continuing to tell the company's story about why the compensation program they've adopted is the right one for them, and why shareholders should vote for the proposal that's on the ballot, whether that's the annual or other advisory vote for, say, on pay, or whether that's a stock plan proposal. So companies could always do that, and I think ISS just doesn't want to be roped into that process and promote and end up, allowing issuers to ride along on their advice to their clients. They also had concerns, and some of the changes that you mentioned with respect in the final rules with respect to conflict of interest disclosures deals largely with the fact that ISS really has a conflict of interest type situation built into their business model on executive compensation issues in particular, because they, have their clients are companies that money managers, institutional investors who need to vote proxies, right? And ISS gives those people advice. But ISS has a subsidiary or division, and a related party that provides consulting services to issuer companies to help them navigate the process of trying to get a positive recommendation on a shareholder proposal from ISS, the proxy advisory firm. And so ISS says, well, look, if we're going to be involved in this at all, we have to be careful about how and where disclosure is made, because our proxy, ISS would say, our proxy voting advice comes from ISS, the proxy advisory firm, and our consulting advice comes from ISS Corporate Solutions, I think it's called, the consulting firm. And we don't really want people at the proxy advisory firm, part of our business, to know exactly which companies have received consulting services from us, right? So that initial proposal that would have said, okay, you've got to include the conflicts disclosure in your voting report to your clients, ISS pushed back on that and said, well, we shouldn't be made to do that, because then we are kind of tipping our hand to the people who evaluate the proposals that somebody over at our consulting division has given advice to the company on how to get a positive recommendation.
Yeah. Well, you would think that, tell you the truth, if there is that built-in conflict, carrying a statement from an issuer saying you would disagree with the advice for voting a proxy by the proxy voting advisor would actually cure that conflict. But
right.
Everybody has their business decisions to make. But it sounds like the SEC actually sort of split the baby, right? And while they don't have to deliver the opposing view or the issuer statement, there is still a requirement that the proxy advisory service notify their client, on how to have access to that additional information that's been filed by the issuer, by either sending an email with a link saying go to the Edgar website and look at that material, or by putting it on their website or other platform they use to deliver the advice.
That's right, and the SEC put in some safe harbors on how proxy advisory firms might be deemed to comply with these rules, but it kind of still leaves it open to the firms to design something that works best for their business.
Yeah. So we're going to move on a little bit from the actual proxy rules. At the same day that the SEC adopted the proxy rules, they also issued supplemental guidance to investment advisors who are responsible for voting proxies on behalf of their clients. And this guidance, supplemented guidance that was originally issued to investment advisors back in August of 2019. And this supplemental guidance deals with or addresses how investment advisors need to consider this additional information that they're receiving from issuers relating to the advice that the proxy advisory firm is giving them on voting shares, voting shares that they own, how it's considered, when they should consider it, and how it'll affect their vote, and documentation of steps they've taken to review that material. Also, it addresses what are called pre-populated proxy voting forms, and some investment advisors that use a proxy voting service will receive back from the proxy voting service prior to the date that the proxy needs to be cast a ballot that's pre-populated with the voting recommendations of the proxy advisory service. The guidance makes clear that investment advisors cannot just rely on those pre-populated proxies and just allow them to be submitted, but need to review those and ascertain whether or not any additional solicitation materials have been filed by an issuer that may disagree with the advice given by the proxy advisory service, and consider that before submitting the form. So some additional guidance has been given to investment advisors as a result of these proposed amendments. Nathan, I'll give you the final word. Anything else you want to say about the rule and the effect it has on issuers?
Sure, Mike. A couple of things to say here. One, about the effective date of these SEC rules. The rules that state that a proxy advisory firm's business constitutes solicitation of a proxy, that rule is effective 60 days after publication of these rules in the Federal Register. So that's going to become effective this year, as is the rule that indicates that failing to disclose information in a proxy advisory firm's advice about the methodology, sources of information, or conflict of interest might be a materially misleading statement. So those rules are kind of effective very shortly here, and that's important for issuers. Those pieces of the rulemaking really mean that proxy advisory firms are now subject to the anti-fraud rules contained in the proxy rules, and in extreme cases that could mean that an issuer might have a private right of action if they feel they've been harmed by advice from a proxy advisory firm that is materially misleading. With respect to the other changes that we talked about, where we spent most of our time, however, today, there's a delayed effective date. So the SEC is not going to require a proxy voting advice business to set up those policies to ensure that their clients are made aware of issuer responses to their voting advice, or even to include the conflict of interest disclosure in its proxy voting advice or in electronic materials until effectively the 2022 proxy season. So December 1, 2021, the proxy advisory firms need to have those policies in place. As I mentioned, some of the players in the space are starting to move there already, but there's kind of going to be potentially a delayed effective date and continued lawsuits. So it's just going to be really interesting to watch what happens, in the upcoming 2021 proxy season. The rules are not yet fully effective, but will be interesting to see how issuers start responding to to the extent there are negative recommendations from ISS or Glass Lewis, how responses develop, and to see sort of how the proxy advisory firms over the somewhat longer term, what kind of policies they develop to comply with the SEC's rules, assuming they become effective and ISS doesn't succeed in in their lawsuit against the SEC, and how that plays out. You could have the potential for shifts in the relative power of those proxy advisory firms, and certainly something that we will all be watching with great interest in the executive compensation area.
Yeah, and I think it's also pretty interesting, Nathan, that with the rise of ESG funds and other an ESG as an ESG as environmental, social, and governance factors, consideration of those in investment decision-making processes, and how it's moving more into the mainstream of financial analysis, and looking at a company as a viable investment, and the impact side of ESG, which focuses a lot on shareholder proposals and proxy voting, many of which are not consistent with ESG. Not consistent with Glass Lewis and ISS and other proxy advisory services recommendations to begin with. So, as you said, we'll see if the power shifts. Does it shift to the issuer? Does it shift to the proxy advisory service, or does it shift to shareholders?
Yes. Yes.
So there's really three players in this game, even though we've primarily been focusing on just two of them. One last fast recap, Nathan. The ISS litigation. Where is that? And what's its posture right now? And do you anticipate anything happening before December 1st, 2021?
I doubt there will be. There may not be decisions from the court that are meaningful yet, but ISS is scheduled to file an amended complaint by September 18th. So it is going to pick up again. It had been put on hold while we were waiting for the final rules, but it definitely looks prepared to heat up, and we'll see what happens. But I would expect to see more developments there coming soon. Something we'll be watching through the end of this year and into the 2021 proxy season.
Great. All right. Well, thanks a lot, Nathan. It's always great to have you on the podcast. Very informative discussion. So thanks for joining us. And thank you for listening to Market Matters. I hope you found the information shared during today's program valuable. If you'd like to learn more about today's topic, or Thompson Hine's investment management practice group, or the employee benefits and executive compensation practices, please visit thompsonhine.com. With approximately 400 lawyers in 8 offices, Thompson Hine is a full-service business law firm recognized for innovation and client service. Our Smart Path approach provides clients with service that is predictable, efficient, and aligned with their goals.